The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, are Guardian Ad Litem communications and work product covered by attorney-client privilege? We'll first talk about how attorney-client privilege works, then we'll talk about what a Guardian Ad Litem is and how it differs from an attorney for the child and a child's representative, and we'll wrap up by explaining how each of those roles is affected by attorney-client privilege. So first, what is attorney-client privilege? When you're in a legal case, there's something called discovery. There's written and oral discovery. Written discovery is written questions that the other side has to answer in writing, and requests for production of documents that the other side has. Oral discovery is deposition. So basically the purpose of both of these things is to find out information from the other side in preparation for trial so that you have all the facts and information when you try the case. There's certain things that you don't have to give to the other side in discovery, and that is, one of those things is privileged information covered by attorney-client privilege. And so what is covered by attorney-client privilege? One flavor of attorney-client privilege is communications between the attorney and the client. And now there has to be an attorney-client relationship. The communications have to be made in confidence for the purpose of seeking legal advice, and the communications can't be disclosed to any third parties or the privilege is waived. So as long as those three things are true, communications between an attorney and client don't have to be revealed to the other side in the discovery process. The other flavor of attorney-client privilege is attorney work product, and this is basically the thoughts, mental impressions, notes, strategies of the attorney in preparation for trial or litigation. And this is basically what the attorney thinks about the case, not the actual facts of the case themselves. So those are the two different things that can be covered by attorney-client privilege. So next we move into what a Guardian Ad Litem is and roles that are similar before we talk about how attorney-client privilege works for those roles. So a Guardian Ad Litem is an attorney that's appointed by the court to investigate cases involving children or disabled adults, and then report to the court as to what is in the best interest of the child or disabled adult. The Guardian Ad Litem also has the ability to advocate for those best interests. The Guardian Ad Litem can be cross-examined by the other parties regarding the nature of the report. Now, this differs from the roles of attorney for the child and child's representative. If you think about the Guardian Ad Litem as being kind of an officer of the court, attorney for the child is kind of on the other end of the spectrum. They're just an attorney that's appointed to represent the child, and this can happen when the child has a financial interest, an estate or trust, and that's involved. Unlike a Guardian Ad Litem, the attorney for the child does not submit a report to the court. They can't be cross-examined. They're basically just acting as the child's attorney. A child's representative is somewhere in between the Guardian Ad Litem officer of the court and the independent attorney for the child. The child's representative, like a GAL and unlike an attorney for the child, is required to meet with parents and the child or with the disabled adult, and the child's representative does not file a report with the court, unlike a Guardian Ad Litem, and the child's representative won't be subject to cross-examination of the parties. So we've got these three roles. The answer to the question, are GAL communications and work product covered by attorney-client privilege, is no. The GAL doesn't have an attorney-client privilege relationship with the child or the disabled adult. So the communications between the GAL and the child or disabled adult and the GAL's work product is subject to discovery by the parents or by any other parties in the case. However, the attorney for the child and the child's representative do have a privileged relationship with a child. So any communications they have with the child can be considered privileged, don't have to be given up in discovery. Their work product in preparation for the case is privileged work product and also not subject to discovery. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below our YouTube video on our YouTube station. If you liked what you heard and found it helpful and you want to be notified of our daily article and video topics, we post a different article and a different video every day. You can subscribe to us on YouTube, iTunes, and SoundCloud, and that helps us as well. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.